So Mario, Michael, Ted.
Yes, so we only have three for this panel. So I'm not going to say anything. You just turn it over to Mario.
Oh, turn it over to Mario? Yeah, okay, great.
I think Mario's
Perfect.
has a problem.
Yeah, he's starting the car, yeah. That's great. Hey, good morning. Good morning. I'd like to introduce this first panel, which is regulatory obstacles to grid reliability. I'll keep introductions brief so we can get right to the discussion. All of these experts are incredibly impressive, and you can check out their bios on fedsoc.org. That's fedsoc.org. First is Mario Loyola, who's a senior research fellow for the Environmental Policy and Regulation in the Heritage Foundation's Center for Energy, Climate, and Environment. Mario served in the Trump administration as Associate Director for Regulatory Reform at the White House Council on Environmental Quality. We are also proud that he is an RTP Energy and Environment Working Group member. Michael Buschbacher is a partner at Boyden Gray, PLLC. He served as the U.S. Department of Justice as counsel to the Assistant Attorney General for the Environment and Natural Resources Division. He is also RTP's Enforcement and Agency Coercion Working Group Chair. Ted Boling is a partner at Perkins Coie, LLP. Ted advises clients on renewable energy projects, resource development, transportation, and infrastructure. He served at the White House Council on Environmental Quality, in the U.S. Department of the Interior, and in the U.S. Department of Justice in both Democratic and Republican administrations. And our moderator is Jeff Holmstead, partner at Bracewell, who heads the firm's environmental strategy group and formerly served under George W. Bush in the EPA's Agency for Air and Radiation. I'll turn that over to Mario. Thank you.
Thank you very much. Can you hear me okay? Great. Thank you very much, Steve, for putting this event together, and thank you to everyone for coming. So if you were among the people who were hoping that EPA would feel chastened by the Supreme Court's decision in West Virginia versus EPA, you have been sorely, sorely disappointed. The EPA has just finalized in the last week a power plant rule that is far more ambitious and some would say reckless than the Obama Clean Power Plan. This rule, if you add up the numbers, will do nearly, if it's fully implemented, would do nearly nothing about global temperatures, but it will cripple or further cripple America's electricity grid and usher in a painful new era of energy scarcity. We've been looking at some of the same things that Louis Finkel was talking about, and I will just say, with the possible exception of our failure to do anything about Iran's multiple nuclear weapons programs, this is the most alarming thing I've ever seen in my decades of working in public policy. The EPA rule requires all existing coal plants and new natural gas plants that run frequently to eliminate virtually all carbon emissions by using carbon capture technology starting in 2032. The new standards will be virtually impossible for electrical utilities to meet for a variety of reasons. As Louis mentioned, the Energy Information Administration expects virtually all coal plants, or 155 gigawatts of coal plants from which Americans get 16% of their electricity, to shut down by 2032 under the new rule. And meanwhile, the main target of the new rule is new natural gas. The new source performance standards apply to large new natural gas plants. And I will argue that that's the only way that you could realistically fill this shortfall is by a rapid build out of natural gas, which the rule is now making impossible. We've already seen this actually since last summer. So the impossibility of meeting the new standards is a major legal vulnerability. Under Section 111 of the Clean Air Act, the new standards have to be based on technologies that have been adequately demonstrated, which means that somebody in the industry has successfully used it to achieve the mandated emissions rate, which is elimination of 95% of the aggregate emissions of carbon from the power plant. No fossil fuel plant in the world has used carbon capture to get anywhere near 95% reduction in carbon emissions mandated by the rule. And the very cases that EPA cites in the rulemaking for its explication of adequately demonstrated under Section 111 very much cut against EPA's position. EPA is hoping that you don't read them carefully, so I invite you to read them carefully. These cases clearly suggest, and in one case explicitly say, that Section 111, adequately demonstrated under Section 111, is not a technology forcing provision. It is not meant to deploy new technology. It has to be looking at the industry and looking at somebody in the industry who's using that technology for the purpose and at the scale for which regulated utilities are going to have to do it, and successfully achieving that emissions rate. EPA also has to consider cost, and what it's done here is really a fairly brazen accounting trick. It has said it has reduced the cost of implementation by the amount of the Inflation Reduction Act subsidies, which is like saying that costs disappear when you shift them from people in their capacity as electricity ratepayers to people in their capacity, to the same people in their capacity as taxpayers. And the only authority they can point to in the law, this is not like Title II of the Clean Air Act. There's no basis for, the DC Circuit has been very clear that cost means cost, indirect cost, whoever ends up paying for them. And the only basis, EPA says in the preamble to the proposed rule, Congress clearly intended that the IRA would be its only authority for this, for the proposition that Congress intended cost to be reduced in this way under Section 111 is a single statement by one congressman on the floor of the House. And as Justice Scalia, if he were alive today, would point out, we don't know how many other congressmen were even present to hear that statement. Okay. Princeton's, and the larger picture is even more alarming. Princeton's prominent Net Zero America study estimates that 68,000 miles of carbon transport pipelines would have to be built to decarbonize the power grid. Most of that would have to be built by 2032 for utilities to be able to comply with this rule. But that infrastructure build-out is entirely outside EPA's jurisdiction and entirely beyond the control of the regulated utilities, which raises the same kind of beyond-the-fence-line major question that led the Supreme Court to strike down the Obama's Clean Power Plan. And because pipelines are outside EPA's jurisdiction, they are also outside its expertise, something that I hope to talk about a little bit more with Chairman Danley and Administrator Wheeler in the lunch hour. And so, in fact, EPA has no idea how long it would take or how much it would cost to build the enormous infrastructure that would be required for utilities to be able to comply with this rule, which raises prohibitive risk for investment capital. The cumulative impact of the new EPA rule with the chaotic rush to deploy heavily subsidized intermittent solar and wind capacity to the grid is having another consequence, which is that it's poisoning the economics of baseload generation in the U.S. We're going to have a panel on infrastructure permitting and the need for infrastructure permitting reform this afternoon. But even if we were to reform infrastructure, there's now another problem beyond the permitting stuff, which is that even if we did have all of what we've been asking for years in streamlined permitting, the subsidies for solar and wind under the Inflation Reduction Act are making it uneconomical for baseload generation to operate and be able to recoup costs. So even if we were to miraculously open up the infrastructure permitting of nuclear, few nuclear plants are likely to be built as long as the Inflation Reduction Act subsidies are operating. EPA's timing couldn't be worse, as Louis Finkel, as you heard in the presentation from Louis Finkel, supercharged by electric vehicles and power-hungry AI data centers and end-use electrification of residential power needs. A tsunami of demand is headed for America's electricity grid. Louis mentioned that EIA expects 80 gigawatts of demand growth by 2030. Just last week, every time you look at a forecast, it's double the last forecast that you saw. Just last week, ERCOT announced that just in the state of Texas alone, they're going to be adding 80 or 90 gigawatts of demand load to the grid in the next 5 years. So the forecasts are soaring by the month. Meanwhile, America relies on coal for 16% of its electricity, on natural gas for another 40%. So if you add up the expected retirements of coal and the tsunami of demand headed our way, America is facing a shortfall of maybe 30% in grid capacity, maybe 400 gigawatts in grid capacity by 2032. Just to understand how staggering that is, consider that building 100 or 200 new nuclear plants would barely be enough to cover that much demand. And of course, that figure is, I just throw that out purely academically because we've only built like 2 nuclear plants since 1979. And the economics have only gotten worse for baseload nuclear. So the Biden administration is counting on renewables to come to the rescue, but that is an absolute fantasy. If you look at 2023, a record year, the United States added barely 20 gigawatts of new solar capacity and just over 5 gigawatts of wind, but the accredited capacity of those additions are barely 10 gigawatts. And the real number to pay attention to is the amount of utility scale battery capacity that has been added to the grid, which was only 4 gigawatts of utility scale battery. Utility scale battery is the limiting factor on the ability of intermittent solar and wind to be able to fill anything like baseload generation. And so I'm also, like Louis Finkel, don't have a background in mathematics, but at 4 gigawatts of battery additions per year, it'll take us 100 years to fill the demand, the gap, the shortfall in grid capacity that we're facing just in the next decade. And by the way, the Biden administration can't even get out of its own way on renewable energy. A new Bureau of Land Management rule would almost certainly severely constrict the development of new solar power in Western states. Just this week, President Biden rolled back several more of President Trump's innovative permitting reforms, which disproportionately benefited renewable energy projects. The politics of this are something that I hope we can get into over the lunch hour as well. And of course, the Princeton study, net zero study, suggests that 600,000 miles of new transmission lines would be required to connect a net zero grid with renewable energy to the grid in a low carbon scenario, yet building even a 700-mile transmission line in the middle of absolutely nowhere takes 15 years. So the only way to make up the looming shortfall would be through a massive expansion of new natural gas capacity, but of course the new source performance standards in the rule that principally target new natural gas baseload capacity. In fact, it's already frozen investment in this sector. The new source performance standards under Section 111 go into effect when they are proposed in an NPRM, which was last May. I did some research, and I've come across there's not a single natural gas, new natural gas project permit application whose permit was pending for modification or expansion or a new plant last May that has been able to obtain financing since then. So we've already frozen investment in capital formation in the one sector that could fill this gap. So with soaring demand for electricity, America is already facing energy poverty in the years ahead. The new EPA rule will make that much worse. And at some point, you have to start asking yourself, 700 people died in the Texas ice storm because of the difficulty of managing a grid with all of these renewables on it. At some point, we have to start asking ourselves, wait a second, why is it that climate change is a danger? What risks is society facing from climate change? Disruptions in food system, disruption in health, death due to severe weather. Some of these climate policies are starting to cause these exact problems today, not 50 years from now. You know, as Trotsky might have said, you may not be interested in cost-benefit analysis, but cost-benefit analysis is interested in you. And people do it, and they're going to vote you out of power if you don't pay attention. Thank you very much.
Thank you. So much of what I had planned on covering was table setting and explaining what's happening, and thankfully I think that has been done better than I could by Administrator Wheeler and by Mr. Finkel as well, and by Mario. So I'm going to focus on the how. It's the regulatory transparency project. After all, so I'm going to try to make some regulations transparent. And I think that's all the more pressing because we've got this whole of government approach. This is from day one in the Biden administration. It's this kind of Chinese-style united front approach to regulation that makes opacity a feature designed to hide the costs, to lie about the benefits, to insulate things from judicial review, and to generally make it harder to stop because there are so many missiles in the air. You know, if your Iron Dome of litigation doesn't knock them all out, you've got rockets landing in your proverbial backyard. So let me start quickly on the generation side, on the supply side. I think it's important to understand how the market works or doesn't work. for how we pay for electricity generation, because that's the mechanism by which these subsidies have this market distorting effect that's so damaging to reliability. So, traditional vertically integrated utilities were the way of the past, and a lot of folks maybe 20 years ago thought, well, if we add some market competition to this, we can do better, get more efficient, lower costs, improve reliability. And that led to the proliferation of regional transmission organizations, RTOs, and independent system operators, or ISOs, and basically real-time auctions about who's going to provide the power at any given point in time. And so it's an open access system. To whatever extent that may have been a market, at some point that's gone, because now we have these enormous subsidies for renewables, and those subsidies have a market distorting effect, so they can outcompete things especially baseload, stable baseload generation, coal and nuclear, that you need. And then these systems also don't have adequate disciplinary procedures in place to punish those who fail to deliver. On top of this, you then add the regulatory push that Mario was talking about. I think PJM recently had a report saying even before you factor in the new rule, what's going to happen on their turf, and they predicted 40 gigawatts of capacity, largely coal and natural gas, are going to retire by 2030. So buckle up for blackouts, in other words. And the real effect of these regulations is going to be to drive up costs. Everyone's going to be asking for their own subsidies, or they're just going to shut down, all of which is going to be very bad for everybody. Transmission often gets touted as sort of a way of solving this. I don't think that's the case. I think if you look at things like what FERC is going to do in its new transmission rule, it's just a joke, I think. It's like trying to introduce policy, like blue state policy for being paid for by red states is basically what the rule is trying to accomplish. That's great if you want more subsidies for your renewable business. It's terrible if you want reliable and affordable electricity. What I want to focus on, though, is the demand side. And this, data centers, that's just driven by technology. But the demand with electric vehicles is driven entirely by regulation. And unlike the Clean Power Plan, which was one marquee rule that mandated a transformation of that sector, the electrification transformation is being accomplished by a bunch of different rules, all of which interlock and interact in ways I think are a novel regulatory approach that has not yet been fully appreciated, either by administrative law scholars and practitioners or by the public about how to actually understand what's happening. So there are three legs to this stool. One is EPA's greenhouse gas emissions tailpipe standards for vehicles. The second is the Department of Transportation NHTSA fuel economy standards. And the third is California's special status under the Clean Air Act, which it has leveraged to move away from doing things about smog, which is why they had that special power, to doing things about global climate change. So let me take them in order, and then I'll hit a few of the ancillary rules that support all this. So EPA has promulgated an initial, there are two phases to this. We're in the middle of the second phase right now. So the first phase started in 2021 with light-duty vehicle standards that would force electrification to about 17% of the new vehicle market. And they did this through setting standards that internal combustion engine cars cannot, on average, meet. And they, much like the Clean Power Plan, it set an unachievable standard with the traditional technology and requires you to average in electric vehicles to get to those standards. So in other words, they reverse engineered the preferred outcome that they had. Again, it really reminds me of the Clean Power Plan in the way in which it took a power design to control pollution from the tailpipe of internal combustion engines and use that for this other purpose of mandating a certain type of vehicle that doesn't even have a tailpipe. EPA has no explicit averaging authority. If you actually look at the statute and the regulatory history here, EPA back in the 80s said, well, we don't think there's anything explicit here authorizing us to do averaging, but we think it's a good idea as a flexibility. That flexibility, as with so many flexibilities, has now become a mandate. Similar regulations, similarly structured regulations were just finalized a couple weeks ago. These are much more ambitious. I think was already mentioned today. They're going to drive up electrification to 62% of the new car market by 2032. 59%, or sorry, yeah, 59% I believe is electric, and then the rest is plug-in hybrid. Currently, there are no internal combustion engine vehicles at all that can meet that standard. And then there's a similar rule for the heavy-duty sector, which is going to drive it to about 40 to 50%. And then you have the CAFE standards, right? Historically, what's amazing is greenhouse gas emissions and fuel economy, there's a direct scientific regulation between, or a correlation between the two. Actually, the way we measure efficiency is by actually seeing how much carbon's coming out of the tailpipe. So it's the same job, but because the CAFE statute prohibits NHTSA from considering electric vehicles, the Biden administration split these two regulatory efforts apart, and so now they operate on a different schedule. We're waiting for the new CAFE standards, but they also will drive, they're very similar, driving electrification, and like, it's so illegal. They say that we can consider electric vehicles when we're talking about the years prior to the standard setting years and after, and insofar as they're part of the baseline of what we think is already going to be out there. We just can't mandate any more electric vehicles for those years. Even Judge Srinivasan, when this was argued in the DC Circuit last September, was very skeptical of this. And he said, it sounds like you're reading a statute that says, you may not, as if it said, you may if. So I very much hope that they lose on that. Oh, I should disclose, I'm like in 8 of these lawsuits already, so, and I'm going to be in way too many more. But then the third prong is this California part, right? And California, under the Clean Air Act, there's a uniform preemption provision in Section 209A of the Clean Air Act that says that states can't adopt or enforce or even attempt to enforce any emission standards for mobile sources. But California gets this carve-out if it can show that it needs it to meet compelling and extraordinary conditions in the state. Like I said before, that was initially a smog thing, and it's been transformed into a climate thing, even though California doesn't have compelling and extraordinary, unique climate challenges like they do with smog. So they've got a mandate called Advanced Clean Cars 2, which will drive to 100% electrification by 2035. Other states can adopt this. Currently, I believe 13 other states have, so about 40% of the new car market is subject to California's regulations. Got similar rules for the truck sector and what's called advanced clean trucks. They even have a purchase mandate. If you are a fleet operator under advanced clean fleets, you know, if these cars were and trucks were so advanced, people would presumably be buying them already, but they're not, so you have to mandate it. Advanced clean fleets is then going to drive, if you have a certain fleet size over 50 vehicles or you make $50 million in revenue per year, you've got to electrify your fleet. On top of this, there is the petroleum equivalency factor. When you're doing your CAFE calculation, you get to multiply the equivalency of an EV, whatever the MPG equivalent is. So for like Tesla Model Y, it's 49 miles per gallon. You get to multiply that by 6.67 and then plug that number into your CAFE calculation. It's an enormous regulatory cross-subsidy for EVs. There's a huge market for this, not that it's transparent. No one except for the automakers knows what it is. And then you have a number of other regulatory efforts, like the Federal Highway Administration has been pushing decarbonization plans on states as well. All of these things, like I said, are interlocking. One of the most pernicious ways is the CAFE standards, that baseline I mentioned. They actually bake into that baseline the California mandates, even before they have a waiver. And so it's like, I'm a millennial, so I think about things in Harry Potter terms. And I apologize for that. I have actually read other books, but this is the perfect metaphor, right? It's like a regulatory Horcrux. The soul of the thing, you know, even if you kill the California regulations, the soul of that thing then will live on in NHTSA's and mandate at the end of the day effect just the same. It's kind of a Voldemort way of approaching regulation. So I'm happy to get into more of how I think this is all going to play out, but it's all illegal, and so the enormous demand that's being driven by this is, in my view, built on a foundation of sand. But actually defeating that's going to really require running the table on all of these cases. And that's largely going to come down to whether the Supreme Court agrees to take it. The DC Circuit just a couple weeks ago said on our challenge to ACC1, the initial EV mandate that California had that was granted in got a waiver in 2012. The DC Circuit said, well, we don't think you've shown redressability. We're not so sure that you've shown petitioners that this EV mandate will actually mandate that anyone buys EVs. I think that's pretty implausible. Certainly the automakers like Toyota said different things in their own regulatory comments. But with that, I'll end. I want to highlight the interlocking way that this on the demand and supply side is driving what I think is the crisis we've been all talking about.
So Ted, you're going to have something a bit more optimistic to talk to us about?
Oh, yes, I'm just brimming with optimism. That's my role here. I'm afraid not. I mean, I've got a long experience in this area. Now, I'm also not brimming with literary references, and I never quote Trotsky. But I'm here to talk about, well, sort of queuing off of a report I worked with the Niskanen Center on with regard to our transmission crisis as really sort of the focal point for just generally what I consider to be sort of an implementation crisis. I mean, it's just the workaday problems of actually trying to get the federal government or, federal, state, and local agencies to work together for infrastructure permitting. My particular focus has been on transmission, mostly because that's where clients are in dire straits right now. I should note, nothing I'm going to say represents the views of Perkins Coie or any of its clients. So if I stray into specifics, please, it's just Ted talking. We've had some hard experience. I'm amongst my clients. We've got some offshore wind projects. Administrator Wheeler noted that the Dominion project was one project that was actually on track. There's an ominous note in the trade press this morning about how Judge Lauren Ali Khan had ordered in a PI hearing BOEM to report back about the impacts of wind projects on the North Atlantic right whale. I just came from an offshore wind conference last week where I moderated as guest host on a game show about the complexities of the Marine Mammal Protection Act. It's an exquisite articulation of the precautionary principle, which sort of presumes perfect knowledge about whale populations around the world. But that's significant for any project that's trying to build in the water. Be it, backbone transmission lines to string together offshore wind projects, or the individual projects themselves, as well as all manner of infrastructure projects related to that. I mean, there's the working your way inland. There's a reason why there are no big power lines that reach right to the seashore, because you don't typically have a lot of demand there. Not in Atlantic City or Virginia Beach. And so, we have a crisis of transmission planning to integrate this, potentially vast renewable resource in the offshore. And we also have a number of barriers to actually developing those resources. So there's a reason why it's taken so long to develop offshore wind projects. I mean, I've been working on this since, well, it was 2008 when the Bureau of the predecessor agency to the Bureau of Ocean Energy Management, the Minerals Management Service, did a programmatic EIS laying out sort of the regulatory framework as best it understood at that point. But really, the complexity is not just that; it's all the interactions between agencies and the fact that there's really no one entity that's in charge. There's no coordinating entity that can bring them all together. And the transmission sector, I think, is the perfect example of that. Is we've all been citing the Princeton Net Zero report, and I won't lace my comments with various projections on demand growth because we just know demand growth is going through the roof. The Princeton study talked about how we are falling behind in our investment in transmission, large power lines, 100 kV or above, and that our transmission investment requirements are going to reach more than $40 billion annually by 2031. So we're falling behind as data centers and other sources, skyrocket our demand. Now, at the same time, that transmission system is as balkanized as it was when the Federal Power Act was enacted back in 1920. You have a transition from radial systems where, generators basically, dictated the growth of the transmission system to a network that is imperfectly regulated. We'll see what the FERC rulemaking that's on the docket for this May will produce. But the Coordinated Interagency Transmission Authorization and Permits Program, CTAP, which DOE released its final 216H rulemaking just recently, it's sort of, DOE saying, okay, we'll be the lead agency. But without a lot of the metrics, the capacity, the ability to actually ride herd, to engage at the federal, the state, the local level to bring this to bear. And frankly, in my humble opinion, it would be a wonderful thing if we had better transmission planning for managing both load growth and the development of generation from whatever sources. With a focus on in-service dates for transmission projects. So we knew exactly where are the priorities. I've seen a priority-based approach work in the federal government. We were able to, at times, corral resources, get things through the NEPA process, and it's not just NEPA, it's, NEPA and the interaction of all the various federal agency authorizations authorities and working with the state and local authorities. But, to focus on what are we going to do and when are we going to do it? What's the need here? And not have, as we have in some courts, maybe a federal land management agency or a federal judge at the district court level, generalist federal judge, questioning basically power demand projections. And whether, why do we really need transmission here? Couldn't you just do distributed generation? Couldn't you just do, grid enhancing technologies or, fairy dust or whatever mechanism is to that person's mind necessary to evaluate the purpose and need of agency action? So I'm very focused on the crisis of implementation. Part of the crisis of implementation is just a lack of capacity in agencies. A lack of just technical capacity, but it's also, judgment capacity. I mean, the 2020 reforms to the NEPA rules that Mario and I worked on were built on Executive Order 13807, very much focused on accountability throughout the federal agencies. That senior agency officials would be designated to resolve issues. Not, dictate from on high, this is, who wins or loses, resolve them on their merits, but that we actually get resolution, that we proceed on schedule. That's the major advance of Title 41 of the FAST Act, and have the Permitting Council have some transparency on what we're doing and when we're doing it. But I'm concerned that the Fiscal Responsibility Act amendments, their mandate of 1 year for an EA and 2 years for an EIS, has just sort of driven the problem underground. I'm working with a number of clients who are just finding it difficult to impossible to actually just get to the starting point. Can we just please start that 1 year or 2 year process? Things can take forever if you don't start. I used to think that there was sort of an irreducible minimum amount of environmental analysis. There's been some very good work done out of the University of Utah that talks about, for simple projects, they generally go clear relatively quickly, whether you call them a categorical exclusion, EA, or an EIS. For complicated projects, they're going to go through, a certain amount of time, whether you try to do them as a CA, EA, or EIS. But now I'm beginning to think there's a third category there. It's just the projects in limbo, the projects that can't get the prioritization, the resources, the imprimatur necessary to resolve issues that may be a poorly trained combat biologist, as a former boss of mine used to refer to them as, to get resolution and make sure that we actually meet the in-service date, so that power planning done by, say, like the Mid-Continent Independent System Operator, which leads amongst the ISOs in developing plans for expansion of the grid, that those plans are not hung up at the various levels of the federal bureaucracy. And I refer to the federal bureaucracy with all the due respect as someone who was part of the federal family for 30 years. I'm enjoying being outside and getting a fresh perspective on it. But the challenge is real, and it's a challenge that I think Administrator Wheeler noted has real national security implications. An efficient and functioning federal government is really what NEPA is designed about. And it's designed to facilitate decisions, consideration of alternatives, consideration of short-term, long-term consequences, but make a decision. And that's what I'm most interested in, is what actually gets us to decision-making on things that are recognized at a national level to be in the national interest. So, there you go.
Well, thanks to all of you. I have just a couple of kind of big picture questions. So if power prices start to increase significantly, or there are reliability issues, all it takes is, one blackout to change the politics. All of the requirements that you've been talking about seem to be completely infeasible to me, and ultimately politically unacceptable. How do you see it playing out? I mean, what is going to happen? I mean, we talked about all these problems, and one solution is hopefully to curtail some of this in the courts, but it's kind of a remarkable situation to think about. There was actually a piece this morning in the Washington Post that talked about how climate change policy has driven voters in the EU to the right, as they've seen increases in the cost of fuel and the cost of electricity. That could very quickly happen here too, and so I'm just wondering if anybody wants to put on or look into a crystal ball, and how does this eventually get fixed?
Well, so the purpose that I don't fully adhere to this way of looking at the world, but I think it's a very useful shortcut. The purpose of a system is what it does, and this complicated regulatory push with a bunch of, I didn't even get into the cost-benefit stuff, and it's nonsense, and the social cost of carbon projections, the way that this has been justified economically, really doesn't hold up under scrutiny. To give just one example of how, even on EPA's view, these things are so imprecise. The proposal for the new light-duty vehicle rule had about $380 billion in projected benefits. The final rule has $1.3 trillion because they found a new social cost of carbon metric. Well, that's...
All you have to do is play around with the discount rate. You can get
that's
whatever,
right. The 2% discount rate, you can drive for miles on that. So I think the ultimate goal of this is degrowth. And I think it's to make something that's hard to undo, and that when the pain is felt, it's going to be hard to walk back, because a lot of the decisions to make these things the way they are will have been accomplished and pushed forward in a way that you don't have an immediate fix. I mean, people will revolt against it, and I think that will be a serious consequence, but it's, I think what the Biden administration is hoping is it's not going to be us.
So I think if I can jump in, I'm a little more pessimistic about that, and I don't actually ascribe a goal to what the administration is doing. I think the administration is triangulating among multiple political constituencies. The BLM's new solar rule, which should be called an anti-solar rule, which has just thrown up hundreds of new roadblocks to solar development in the western states, is clearly being driven by a small constituency of environmental advocacy groups that are anti-development in those areas. And even though the initiative started probably on the front end by somebody saying in the White House, hey, we've got an energy supply problem here, we're not deploying solar nearly quickly enough to come up with these demand projections. And yeah, people do cost-benefit analysis, but now we can clearly see around the world that climate policies are being filtered, selected, and advanced precisely on the criteria that their costs can be hidden from the public. So candidate Vice President Biden ran on a carbon tax. A neutral carbon tax would entail a tax on gasoline, of course. By the summer of 2021, if you've never seen Joe Biden run, he was sprinting from the idea of a carbon tax, and by the end of that year was actually proposing, which I still laugh about, to suspend the existing gas tax. And why? Because people can actually see that that tax is a policy whose cost they can immediately understand. Right now, we see in Europe in a very alarming report, alarming even for Americans, that came out from the European Commission in January, that shows industrial production in free fall in Europe, down 10% in the last year at least. Why? Because electricity prices have tripled since 2019. Of course, most Europeans are under the impression that this is because Russia invaded Ukraine and the Europeans had to react with sanctions that cut off that important supply of natural gas. That is certainly what drove the crisis last winter when electricity prices hit 10 times their 2019 level. But the reason why in Germany, for example, all of this nuclear power had to be retired wasn't that the Greens arrived and Angela Merkel decided to give in to them all of a sudden. It was that this inordinately chaotic, to use McKinsey type language, chaotic deployment of solar and wind 15 years ago to the grid made the entire grid incompatible with baseload generation. So there was not, if you look at the amount of intermittency on the German electricity grid, the nuclear plants couldn't operate economically anymore because they couldn't operate at greater than 30 or 40% capacity. And people don't understand this stuff. Like people in Europe, you ask people in Europe why their electricity is 3 times higher, and the answer is not, you're not liable to get from many people the answer that they've mismanaged their electricity grid. And so by the time, what I worry about is that by the time Americans understand why we're facing electricity shortages, and then of course, the problem with socialism is that it's never really been tried, and so now its failures, are an excuse to try, to do for more of it. It could be a very long time before people figure out what's gone wrong and develop a consensus for what to do about it.
Well, not being a politician, but I would expect that there would be a great hue and cry about trade-offs that don't seem to make sense, where the juice is not worth the squeeze. The process takes so long. The public process, ostensibly for the public benefit, doesn't really benefit the public because it's so opaque. Or that mitigation requirements don't have the sort of nexus and proportionality that makes sense. I mean, I'll just give you the example of the kind of negotiations you go through to develop an offshore wind facility, and you'll have a group for one reason or another say, well, could you build fewer towers out there? Like, okay, let's look at the trade-off in terms of lost power versus what's the benefit to the clams, the whales, or whatever is being supposedly protected by fewer wind turbines on that lease. Those trade-offs, if they were made clear, wouldn't really stand up to a whole lot of scrutiny. Like, but we're constantly making those trade-offs, and opacity is the real problem there. It's sort of like different groups want different things. The way in which we reconcile them should ultimately make sense and be clearly articulated. But if it's not, that's where I think you're going to find a real a great hue and cry. Now, I also think that litigation is a real problem. It is more problem in perception than in reality because it's fear of litigation that is the mind killer. Now
you're quoting a book.
All right. I saw the movie recently, so that's Dune. That's Dune, for yeah. It's one of the greatest passages. It's fear of litigation stymieing agencies. I used to love to run into court. Let's get that administrative record together. We're going to go defend this project. It's the right thing. That should be the attitude of the federal government. We make good decisions. We went through the right process. We did it. But there seems to be this fear of litigation, mostly by non-litigators, that rules the day. And frankly, and I'm currently fairly down on district court judges, but I think a lot of these projects, you go through summary judgment briefing, and then, you go all over again at the Court of Appeals. And you got de novo review of summary judgment briefing. What did we just go through at the district court level? Why? The Natural Gas Act, you go directly to courts of appeals. And frankly, everything that's a policy priority, an infrastructure policy priority that's in the national interest, if it's on the permitting dashboard, part of putting a project on the permitting dashboard ought to be you get a shorter statute of limitations and you get to go straight to the Court of Appeals. So now that's pure TED advocacy there, but I think some judicial reform might be in order too.
Can I respond very quickly to one thing? This is hearkening back to the wonderful conversations Ted and I used to have when we were working on these issues in the White House. I think that it's, agencies win 70% of the time, is that
Yeah,
right?
the arbitrary and capricious standard actually works out the way you'd expect it. Agencies usually win, unless you're the Forest Service.
So I think that this I think that this 70% statistic is actually a terrible statistic. If agencies spend, this is like, in the criminal context, if a prosecutor's Title III wiretap affidavit only gets results in a warrant 70% of the time, that person's going to lose their job. You agencies that spend millions of dollars of taxpayer resources and thousands of staff hours trying to comply with the law should be able to have some idea of what the law requires. And the fact that their EISs only get upheld 70% of the time means that these agencies have no idea and only are going to find out in court what the law required. And that is a problem, right? That means that NEPA, the way that it's been administered by courts, fails a basic principle of Lon Fuller's principles of the rule of law, which is that nobody knows what in the hell the law requires. And that is a problem. And
I'll say, and Mario's familiar with this line of reasoning, he's just looking under the lamppost as to the projects that actually get sued on, which, if you're doing an EIS level infrastructure project, you probably have a 50-50 chance because infrastructure projects necessarily, they go through somebody's backyard. There are real trade-offs there. Down at the EA level, those are rarely sued on. Categorical exclusions, it was once in a blue moon. We're sort of pushing the envelope on categorical exclusions, so you're starting to see a little bit more litigation, but nowhere near the hundreds of thousands of categorically excluded decisions that are made in a year. So again, I think the litigation risk is blown out of proportion. And another part of it is, federal agencies have to respond to applicants, and it's not their project. So unlike, the wiretap or, having had a search warrant denied, I know that, you pick your battles there. Federal agencies have to respond to the applications.
So, Michael, I want to go back to you on the EV mandates. California has kind of a long history of setting unrealistic requirements. They're sort of reasonable for the first few years, and the idea is, we'll push the pain out, and industry will respond. And then, after a few years, and that turns out to be implausible, they just push them out a little further and make them even a little stringent, but they keep pushing that out. Are we likely to see the same thing with EPA? And
No, I don't think so, because California doesn't operate under the rule of law like the rest of the country. Like, you read these regs, no, you read these regs and they have like, what are the penalties for violating it? 40 different provisions of the California Code of Health and Safety. They won't clarify for you what the penalties of any of those would be if you violated this. Maybe you'll go to jail, maybe nothing will happen. They are also very dynamic, they can move very quickly. EPA's got the Administrative Procedure Act to deal with. It has the fact that it can be sued in many different venues often. Not so much with the Clean Air Act 307, all the nationwide emission standards have to go to the DC Circuit.
Yeah, too bad about that.
And that takes forever. So I don't think they can have the same kind of flexibility that California does. California approaches all of this like a mob takeover. The threats are not really there to get to that end. It's to put them in the driver's seat, so to speak. So it's a different modality, and different rules apply. So I don't think so. Which means that it's going to be hard to undo if we end up in a pinch point with this, which I think we will.
So in just a minute, we're going to take questions from the audience, but one other sort of high-level question. especially listening to Ted, but I think all of you, it seems like unless we can get major changes to the underlying statutes, there needs to be more government officials who can move these projects through the pipeline.
Yeah, I don't look to Congress to act in a coherent and rapid manner in this regard. I think the onus is a responsibility to take care of, see the laws are faithfully executed. It's in the executive branch. And, you know, frankly, it's that authority to organize federal agencies, to manage. I mean, that's the responsibility. That's the price of governing. You wanted the job, you know, you need to make sure that, you know, everything from, you know, student loans to, permits to build in wetlands are managed in an efficient and coherent way.
So we need to expand the size of the federal government.
I don't know that expansion is really it. I mean, it's actually, you know, frankly, it's the efficiency with which it works. It's not the number of bodies. I mean, you throw a lot of money at problems, but that doesn't necessarily solve the problem. In fact, you can hire people, fresh out of undergrad, and they may come to it with all sorts of ideas. I'm going to use my little piece of authority to reform the world. They're like, well, that's what managers have to deal with.
Yeah, so I think that the resource, under current law, the preparation of these environmental reviews requires such enormous commitments of agency staff resources. Just to give one example, in the Nevada office of the Bureau of Land Management, they are facing 30 project permit applications with the same staff that was processing, that has never been able to issue more than one EIS per year. And that was only working on 1 or 2 project applications 10 years ago. The Inflation Reduction Act tried to address this by, I think if I remember correctly, it was like $1 billion of, was it $1 billion? What was the figure of? Like the $200 million for FIPSI?
Like Carl Sagan said, billions and billions.
How many, I forget what the number was, but whatever it was, and it sounded like a big number, we did a back of the envelope calculation at the time, it would barely have been able to help BLM to clear the backlog of permit applications.
If I could, Professor Jamie Plune and her colleagues at the University of Utah did a fascinating study of Forest Service decision-making, and also they also broke down BLM decision-making in terms of really sort of the management of the process. And they were able to show that, you know, like certain field offices of the BLM operated on APDs with amazing efficiency, whereas others didn't. And it wasn't intuitive. It was like, you know, the Anchorage office was, you know, led the pack in terms of their efficiency. Miles City, Montana, I would have thought would have been fairly efficient, but, you know, for some reason they had some management issues here. And that was, you know, I was the deputy solicitor for land resources. I worked with the BLM, and I could see the difference in management and the quality of management between, you know, various offices. I mean, really, you have to get down into the weeds in order to find the weeds.
It doesn't seem like that's amenable to any sort of easy fixes. That's
No, and it's not like you can say training or diet and exercise will solve this problem.
Are there, I promised we would leave enough time for questions from the audience. Are there questions? Please, step up to the mic.
I'd like to get the panel's thoughts on the likelihood of there being an open, transparent, fair public debate about trade-offs involved in
I think most of us know you, but please introduce yourself.
Hi, my name is Justin Schwab. I would like to get the panel's thoughts on the likelihood of open, transparent, fair public debate about trade-offs involved in environmental policy in light of the fact that the former EPA administrator and then national climate advisor repeatedly in national media in the 2021 to 2022 timeframe called for the very successful approach to discussion on such topics as COVID-19 vaccines and the 2020 election. She repeatedly called for that same model to be imported with respect to what she referred to as climate disinformation. I think that this is a fantasy to think that there will be a fair and open public debate about trade-offs involved in environmental policy, and I'd like to know if the other panelists agree with me.
I think there is zero chance because they know they will lose on basically everything they want to do, and the things they want to do can't happen. We're not getting to net zero by 2050. We're not going to have a 100% renewable grid. All of these things are not defensible on the merits, which is why they have to be dishonest in their regulatory impact analysis. It's why they have to get out there and make sure that true information is labeled disinformation. I think the reason why you see that push towards that is precisely because they fear being put on the record with an actual, real, fair discussion of it.
You know, NEPA is designed to actually have that kind of dialogue, you know, short-term, long-term trade-offs, what are the benefits, not necessarily getting into discount rates and that, but really just, you know, articulation, a reasonable articulation of the significance of what we're doing and, you know, what are the consequences going to be. And I've just been amazed at the number of times I see for, say, like a renewable energy project, we routinely say, oh, it'll produce X many megawatts, which will, you know, power X many homes. That's the metric. It gets tried out time and time again. It was like, no, but it's going on a grid at a particular place, a particular, you know, profile. You know, what's this project going to do? Is it just going to, you know, feed a data center, or, you know, how's this power going to be used? And there's no information about that. It's very, very seldom do you actually see something that's actually locality based and says, okay, so here's the real world. You know, you may have this sort of an affinity for greenhouse gas reduction, but here are the real world impacts of this project.
Hi, I'm Peter Humphrey. I'm an intelligence analyst and a former diplomat. As far as the data centers for artificial intelligence, we're stuck with that. It's going to happen. But there's another utility for data centers that we're not stuck with, and that's the production of bitchain, of cryptocurrency by blockchain. And China looked at this and said, this is a stunning waste of electricity for our country, and so we're going to forbid it. And that means that a Chinese person can get a visa to go to the US, an investor visa, can then go to a state with low energy cost, establish a data center, and produce cryptocurrency using American electricity for China. I'm wondering if there's any room at all for our regulators to say, basta, enough. We're done with this. We're not going to help China. We're not going to waste all of our energy on producing fake money. We're going to stop it.
I'll just address that quickly by saying that I think this is a significant, but in the bigger picture, what's really driving data center demand in the years ahead is the astonishing amounts of compute power that training and inference requires in any kind of, for example, large language model. I'll just have one quick fact. A AI-assisted Google search consumes more than 100 times more electricity than a simple Google search. And everybody is adopting AI. We've looked at some of these numbers right now. We've often heard that Google consumes more electricity than the country of Ireland. The country of Ireland is fairly small. At the rate that we're going in the next 3 or 4 years, the big four, Meta, Amazon, Microsoft, and Google, will be consuming more electricity than the entire country of Australia, which is the world's 10th biggest economy. So these projections are really enormous, and tamping down cryptocurrency, I'm not sure that would really register on the amount of demand that's headed our way.
So the Chinese were foolish to expulse that?
The Chinese have a bigger problem, I think, and we can get into this discussion. Maybe this is for a future regulatory transparency project, but the Chinese have now become the world's principal exponents of the European Westphalian nation-state system. And they, in the sense that they claim everything national sovereignty. And anything that's blockchain threatens the political authority of the state, and so they will move against it.
No, I agree. If it's so worthless, it's strange that so many people would be investing in it in free market countries, right? I'm not a big Bitcoin booster, and it doesn't interest me that much, to be frank. But the notion that essentially planned communist country is going to have better insight into what's valuable and what's not compared to the market seems to me unlikely to be true. And if it's so expensive that it becomes infeasible to do, well then, you know, there are market signals that increases the transaction cost at some point for Bitcoin mining or whatever it is that you're trying to do. So I don't see that as a necessity for a government regulation to fix energy scarcity. And the other thing is that the notion that you have, this is what Mario was talking about, like the central planning state is threatened by things that it can't control. And if we're talking about fake money, of course, that is basically all money nowadays. And so, you know, fake money that the government can't control versus fake money that the government can control, I mean, it doesn't strike me as having a strong valence one way or the other on this.
Please.
Hi. My name is Samar Chatterjee, Safe Foundation. Not being a lawyer by profession, as an environmental engineer involved in environmental controls and environmental improvement, we have always found that whenever the technical people in EPA provided details to environmental controls, and when it went to the lawyers, it just did some difficult and a lot of problematic things. And so, but yet from 1970 to this day, we have had environmental improvement, so there may be something good in it. Now my question is, will the election, since you say that there are regulatory hurdles and that may result in energy scarcity, and will the next election have any impact? Could you analyze that and tell us if that would make any impact?
So let's just assume that we have a change in administration. What do you think we might see? And how much could it make a difference? Without congressional reforms. Let's assume that for now.
Exactly. Great framing of the question. I think there are rules. You know, we worked on the Trump era permitting reforms, and we tried. I know I tried to make them as bipartisan as possible because we knew that we would need. And I think permitting reform is going to have to need a bipartisan consensus because nothing is worse than politicizing the permitting regime and having it just turn into a ping pong that change. It was bad enough already. To have it change every 4 years is just going to introduce even more uncertainty into the process. EPA, on the other hand, has been, as the focal point of Democratic Party's climate strategies, has been really swinging for the fences. The Clean Power Plan, you know, the Obama administration knew that rule was dead as fried chicken if the Republicans won the 2016 election, and they wanted to and it survived court, and if it could survive court review, it would be withdrawn. And that's even more true for this rule. I mean, this rule will be withdrawn instantly.
The Clean Power Plan was modest compared to this
modest
rule.
compared to this. These rules will be withdrawn instantly if the Republicans win the next election. But look, what we did, and we'll go into this in the afternoon panel more, what we did in the Trump administration, what the Biden administration, what the Obama administration has done on permitting reform, what the Trump administration, it's tinkering at the margins of a problem that only Congress can solve. And the politics of it are just a big public choice problem that has defeated any of the significant permitting reforms. Right now, even if we were, and we'll get into this more in the afternoon, but even if we were to miraculously fix the permitting problems, we've got another problem, which is that the Inflation Reduction Act subsidies are poisoning the economics of baseload generation. So we now need congressional action to at least have a sunset of those subsidies in some year of our Lord that's not this fantasy of reaching 75% of Paris Agreement targets, which could be like Buck Rogers in the 25th century before we accomplish that. That was, okay, not a literary reference.
Well, it was kind of a literary reference.
Yeah.
I would say yes, but there are a couple of caveats on it. One is how effectively repeal rules and settlements of litigation are accomplished. We saw at the beginning of the Trump administration the last time that a lot of attempts to change course were stymied in the courts. Two, the courts, is the Supreme Court going to police the lower courts, or is it going to have a more hands-off approach? How much Trump law are we going to get with Trump 2.0? It's big question. I think you're going to see, you know, all the fun that the Northern District of California was having, all the fun that the
Montana?
Yeah, Montana, all the fun that was going on in Hawaii. I think we're going to see a lot more of that. How effective that is at stymieing change and how long they can hold that off, it's an interesting question, I don't know. And the third variable, I think, is whether there are ways in which changes can be sort of baked in to make them more lasting. If industry looks at things and sees an uncertain regulatory environment where they think there's a good chance things are going to still go in the direction they're going now, they're going to be building for that future and not for whatever you might put in a regulation that might be gone in a year.
I'll just sort of align myself with Mario's remarks. And I think the goal for any administration should be not swinging for the fences on a particular policy, but seeking durability, seeking impact that lasts over time. And so, you know, so the 1978 Carter administration NEPA regs were on the books for 40 years.
You know, can I just interrupt and say, I used to think that was possible, but I looked at the permitting reforms that the Trump administration did that really were pretty modest, and yet they were, you know, villainized, and because they were Trump administration, they, you know, they had to be undone.
And not just modest, but disproportionately benefited renewable energy.
Yeah, and that's, and I share the fear that we're now into a ping pong on various issues. You know, it's WOTUS and just tick, 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 tick. You know, ideally, that, you know, this administration and any administration would be looking to try to settle that down, recognizing that, you know, just by nature of the democracy, you're not going to be in power for forever.
Yeah, but your constituents want you to be in power. Anyway,
Yeah.
I hate to be so pessimistic, but please.
Bonnie Wachtel, I'm in the investment business. Great panel, by the way. Mr. Boling, your comment, the comments about California, I'm reminded of the statement by Milton Friedman that efficiency in government is not necessarily an asset if the end they're pursuing is wrong. That is not necessarily applicable here for permitting, but I just put it out.
Yeah.
Here's my question. I'm really like the question posed by the moderator about ultimately where are we going? And I am in no way connected with the nuclear industry, but from what I read, my understanding is that has to be where we're going ultimately, if for no other reason, just driven by the defense imperative. We can't be relying on Chinese solar. We have to have the cheapest energy around. Silicon Valley is going to do it anyway because they need this unlimited energy. And if people are going to hate fossil fuel so much, it's the only place to go. Your reactions?
Well, I'll just start as, you know, certainly recognize that sometimes inefficiency has its own goals and its own purpose. And ultimately, you know, those goals should be transparent. And I'd say, you know, I started off, I've worked through several nuclear renaissances, and I was holding out the hope for, you know, pebble bed, walk away safe nuclear reactors as we were working on during the Bush administration, and you know that, and I would like to see that regulatory regime become more efficient. To, you know, get over the, you know, the 3 Mile Island Fukushima, you know, paralysis and move forward. I'm afraid that I like to work on things that work, and I like to see things get built, and so I'm a little impatient, and I haven't had the patience to stick with nuclear. My hat is off to people who stick with it, and I appreciate their professionalism.
Is anybody optimistic about SMRs?
I am, but with a big caveat, which is the industry needs, and the lawyers who represent the industry need some change. I'll just give one anecdote. I had a pitch that I've been kicking around that involved a regulatory challenge to some of what the NRC has been doing vis-a-vis SMRs. And you know, someone got a second opinion, and I saw what this big law partner who has been doing this for his whole career said, and it's like, don't you understand, back in the 70s, the DC Circuit said the NRC can do whatever they want. So this is stupid that you would ever want to challenge any of these things, because that's the way it should be. It's like, if you're representing an industry and you've only gotten 2 reactors of any significant size built, I don't think you're going to be effective for an effective advocate for it. So if that change, I mean, the fundamentals are good. I mean, the reason SMRs are attractive is simply because it's so hard to make big stuff.
Right.
But the fundamentals are very attractive. I think there is a real future for that, but it's going to take changing the NRC and the folks who practice in front of it.
Yeah, and I'll just say that if there's one thing that Senator Bernie Sanders has always hated more than the Vietnam War, it's nuclear power. And the Progressive Caucus in the House is in lockstep with him on all this stuff. And as much as I love the idea of a hippie revival, it's really bad for nuclear power.
So Andrew Shinsky with Interstate Natural Gas Association of America. Thank you all. One of the things I wanted to question, Mario, you brought up the Clean Power Plan 3.0 now. Obviously, at the time that was argued, that was prior to the IRA. Talk about adequately demonstrated and all that technology. Does the IRA change the calculus under the underlying substantive question for a court taking that up to say, okay, it was subsidized, now it's adequately demonstrated such that we can promulgate this rule moving forward?
So those two things are orthogonal, however you say that word. Though I don't think that those two things are related in the sense.
But just a second, I thought there was that legislative history that says that was the whole reason for the IRA.
Well, but there's, right, one statement by one congressman that was said, that said, we expect the IRA subsidies will be used to reduce costs. Under Section 111, it's the best system, the emissions rate has to be based on the best systems of emissions reduction that the administrator determines has been adequately demonstrated, taking costs, non-air health benefits, and energy requirements into account. But at a basic level, the question of adequate demonstration is, let's look around the world and see whether any fossil fuel, any coal or natural gas plant on planet Earth has been able to use carbon capture technology to reduce emissions by 95%. And if you can't find a single example, and there aren't any, for this particular emissions rate, then it doesn't matter what the cost is. Now, I think that the cases that, again, I urge everybody to read the cases that EPA is citing for adequate demonstration, because they really cut against, they really show that EPA is going to face an uphill climb convincing the DC Circuit that this stuff has been adequately demonstrated. But of course, it has to take costs into account. And that can't be, as fabulous as the, hundreds of billions of dollars of net benefits are that EPA puts into every rule these days. There is no legal basis for reducing the cost calculation by the amount of those subsidies. None. One statement by one congressperson is not going to suffice.
Can I take moderator's prerogative here and just answer one other part of that? So I agree with all of that, but I don't think it's enough to find a handful of plants that do this around the world, because in EPA's own view, the system of emission reduction has to include a system of pipelines and sequestration. I mean, you need the whole system, even if you believe that this is something that EPA has the authority to do, to require people to take measures that are completely out of their control. But the idea that we have a system of emission reduction that includes thousands of miles of CO2 pipelines and sequestration sites, and yet again, we have an administration that is working completely at cross purposes, because they mandate CCS, they supposedly support CCS, but do you know how many permits they've issued for CCS in the last 3 years? 0. I mean, there's no, and they claim that they're getting ready to, but it's not for a power plant. So anyway, I don't think the IRA helps them, and I'll go out on a limb and say I don't see how this stands up in court. But
if I may, just following up, because one of the things that the panel discussed was cost-benefit analysis and the fact that they hide the costs or lie about the benefits. So to kind of politely push back on the orthogonal portion of that is to say, wouldn't we have to have an accurate accounting of what those cost-benefits may be? Because if they're the ones saying what the cost-benefit looks like, wouldn't that change that calculus?
Sorry, to ask that question again.
So you're saying because there's nothing that's adequately demonstrated based on cost benefit, correct? But we're saying before, if cost benefit is predicated on, hidden costs and lied about benefits, wouldn't that change the calculus, to your point?
Oh, I mean, yeah, I just think that when this gets, if I understand your question correctly, when this goes before the inevitable DC Circuit, case on this is going to look very closely at every one of those elements in Section 111, energy requirements, cost calculation, adequate demonstration, of course. And I think, there's certain aspects of this that we can object to, but it's like water under the bridge. I mean, net health benefits, using statistical life and express preferences to calculate net health benefits is something that EPA has been doing for a long time. This will not be like the most opportune moment to litigate or relitigate that necessarily. But one major vulnerability, and I hope to get into this over the lunch hour with Administrator Wheeler and Chairman Danley, is that there's a lot of, again, the outside the fence line stuff, this build out of carbon transport infrastructure, it's not just outside of EPA's jurisdiction, it's outside its expertise. And so all of its speculation is just the agency not knowing what it's talking about, how long it would take, how much it would cost to build this pipeline infrastructure out. And so, query whether, what level of deference courts give to agencies at the frontiers of science when the agency manifestly doesn't know what it's talking about.
Thank you.
Depends on your judge draw. If you get Judge Ginsburg, which you won't for this because it's a big case, and he's senior status, yeah, but I'm not so sure about everyone else on that court.
Well, this has been a very interesting, if somewhat sobering, discussion. And I think we've managed to stay exactly on time. So it's 12 o'clock. I will thank all three of you for really a very interesting presentations and especially interesting discussions. Thanks to all of you.
Thank you.
And thank you for this terrific panel and discussion. Just 2 points of, we have a buffet lunch, which is on the left side of the room, and you can help yourself. And the second order of business is there should be Wi-Fi passwords on your table. You're looking for the Marriott Bonvoy network, and the password is one word, FedSoc 2024, FedSoc 2024. Thank you.